One of the major reasons I hear people talk about amending the Constitution is to rein in these out of control federal agencies and especially the rules they keep promulgating. However, a quick reading of the Supremacy Clause in the 10th Amendment proves we already have the tools to do so. Starting with the Supremacy Clause. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. While this clause makes quite clear what the supreme law of the land is, it also allows us to determine what is not the supreme law of the land. Federal regulations are not listed as the supreme law of the land, so they are not. In fact, they are not law at all, since Article 1, Section 1 clearly states, all legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. All power for making laws, legislative power, is vested in Congress. Now, since all federal departments and agencies are part of the executive branch, they are prohibited from making laws or anything treated as such. And since the Constitution does not delegate to Congress the power to delegate the power to make laws, every piece of legislation where they claim to is itself unconstitutional. And according to Alexander Hamilton and several Supreme Court decisions, such acts are void and of no effect. Alexander Hamilton wrote in Federalist 78, no legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. From Marbury versus Madison we read, certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. Then in Ex parte Siebold we find, an unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void, and cannot be a legal cause of imprisonment. Finally, from Norton v. Shelby County, we find, an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. Since the Constitution did not delegate to Congress the power to create federal departments and agencies that enforce powers not delegated to the United States, all the legislation that created these agencies are unconstitutional and therefore void. Furthermore, all the legislation that appropriated money to these agencies is void, making their funding embezzlement. But Paul, if the Supreme Court has already weighed in on the legitimacy of these agencies, how can you claim they don't legally exist? Go back to the Supremacy Clause, and do you notice what is not the supreme law of the land? The decision of a court, any court, including the Supreme Court. I know you've been taught that the Supreme Court is the final arbiter of what the Constitution says, but that simply is not true. Nowhere in the Constitution is any part of the United States delegated the power to be the final arbiter of its meaning. So according to the 10th Amendment, that power is reserved. Well, who is that power reserved to? Well, since it's not prohibited by the Constitution of the states, and since the states are the only legitimate ratifiers of the Constitution and its amendments, they are the final word on what it means.